Hello everyone, this is Amber Rouse Holloway, and I'm a partner here at the Troy office of Seekers Wardle. You are now listening to our December 2020 episode of My PIP Monthly. So our December 2020 topics include, of course, our case law update. We'll be discussing Covenant Medical Center v. Farm Bureau, Bronson Healthcare Group v. USAA, El Ashkar v. Sentinel, and for trending topics in PIP litigation, we'll be discussing the new 2019 no-fault reform and the one-year back rule. First up for our case law update is the case of Covenant Medical Center Incorporated v. Farm Bureau. In this case, the Michigan Court of Appeals vacated and remanded the trial court's order granting plaintiff's Covenant Medical Center's motion for summary disposition. The court held that the trial court did not resolve whether defendant failed to properly provide payment or appropriate reimbursement under the Medicare Secondary Payer Act, or the MSPA, and that double damages could not be imposed without such a determination. Just as a background, the MSPA provides for a private cause of action for double damages in the case of a primary plan which fails to provide for primary payment. The MSPA also provides that when a reasonable primary plan does not promptly meet its obligations, Medicare is authorized to pay the entire amount, and the primary plan is then obligated to reimburse Medicare. The facts of the Covenant case are fairly simple. Defendant insured Nancy Hutchinson, who fell and was injured while trying to enter her vehicle. Hutchinson was attempting to drive to the emergency room to seek medical care for complications from a surgical procedure she had undergone just a few days earlier. While she was initially hospitalized at plaintiff's facility, Covenant Medical Center, from November 19, 2015 through December 2, 2015, Hutchinson received medical treatment for both an infection related to her prior surgical procedure and injuries resulting from the fall. At the time of the fall, she had an active policy with Farm Bureau and was also covered by a Medicare Advantage plan through Blue Cross Blue Shield of Michigan. According to Covenant, the plaintiff in this case, Blue Cross Blue Shield of Michigan billed Hutchinson for her medical care. Included in this amount was $6,294.81 for Hutchinson's Medicare on or about November 19, 2015, which defendant asserts that was related to complications from an earlier surgery and was not related to the no-fault accident. Plaintiff thereafter goes on to provide defendant with several other bills. Defendant received information that Blue Cross Blue Shield of Michigan had paid a certain amount of those bills on behalf of Hutchinson, and therefore defendant then paid Blue Cross Blue Shield of Michigan for services provided to Hutchinson. Meanwhile, plaintiff would ongoing bill defendant for certain amounts, even though Blue Cross Blue Shield of Michigan was also billing defendant. It should be noted that defendant also paid plaintiff, not Blue Cross Blue Shield of Michigan, for certain amounts that it had not paid Blue Cross Blue Shield of Michigan. Before receiving any payments from defendant, plaintiff initiated the lawsuit by filing its complaint on November 18, 2016. Plaintiff's complaint, of course, alleged that defendant had breached his contract with Hutchinson by failing to promptly pay plaintiff under the No-Fault Act for her care. Plaintiff also alleged that defendant had failed under the MSPA to provide primary payment, and as a result, Medicare made conditional payments to plaintiff on behalf of Hutchinson for medical services for her injuries related to the motor vehicle accident. Plaintiff alleged that it was therefore entitled to recover double damages from the defendant under the MSPA. Of note, the MSPA statute also provides for recovery of double damages when a primary payer fails to pay or reimburse but does not provide for double damages for tardy payment. Thus, without a finding of the trial court on whether defendant failed to provide primary payment or appropriate reimbursement under the MSPA, double damages cannot be imposed. In the trial court, both parties moved for summary disposition, but the trial court granted plaintiff's motion in part, finding that plaintiff had standing to pursue the claim under the MSPA and that defendant was a primary payer under the MSPA and defendant had conceded that it was obligated to pay plaintiff's charges. Interestingly enough, the trial court found that the question of fact existed regarding whether defendant had failed to provide primary payment or appropriate reimbursement under the MSPA that would entitle plaintiff to double damages under the MSPA. Under the double damages provision of the MSPA, the trial court awarded plaintiff damages. The trial court reasoned that because Hutchinson was injured while getting into her car, defendant as the no-fault insurer or primary payer for Hutchinson was obligated to reimburse plaintiff for Hutchinson's medical expenses. The trial court found that there was no genuine issue of material fact that defendant was a primary payer under the MSPA, but found that there was a genuine issue of material fact whether defendant failed to provide primary payment or appropriate reimbursement within the meaning of the MSPA. Well, defendant argued that plaintiff was seeking payment from defendant for amounts not within the contractual obligation of the no-fault policy. That would be Ms. Hutchinson's treatment that was not related to the instant accident. And that issue was never resolved by the court, so it was defendant's contention that the double damages was not appropriate. Here, the Court of Appeals ultimately found that the trial court did not resolve whether defendant failed to provide primary payment. Defendant did make some payments and decided not to make other payments, but the payments that weren't made by defendant were related to the treatment that was not related to the subject motor vehicle accident. Ultimately, the court directed the trial court on remand to determine whether a genuine issue of material fact exists regarding 1, whether the amount allegedly not reimbursed by Blue Cross Blue Shield of Michigan is compensable under defendant's no-fault policy, and 2, whether defendant failed to properly provide primary payment or appropriate reimbursement under the MSPA. In this slide, I just simply talk about that when a responsible primary plan does not pay promptly, Medicare is authorized to pay the entire amount, and then the plaintiff may seek the double damages. Next up is the case of Bronson Healthcare Group v. USAA Casualty Insurance Company. Here, the court affirmed that the no future assignment provision of MCL 500-3143 applies to any no-fault benefit incurred after the execution of a purported assignment. The court here rejected the proposition that an assignment could survive this rule so long as it was executed contemporaneous with or immediately prior to the treatment which was the subject of the assignment being actually rendered. We all know that it is well established under the no-fault statute that an assignment for future benefits is void as a matter of law. The exact same timeline for when an assignment qualifies as a future assignment has been contested in the recent years due to the influx of provider cases and the Covenant Medical Center case. Here, the plaintiff, as a part of their operating procedure, had its patients sign various paperwork upon presenting to the emergency department, including a document that was titled an assignment of rights. It goes on to state that it is an assignment to pursue payment of my bills, and it gives the Bronson Lakeview Hospital the right to file a lawsuit to get payment of a bill. Thereafter, when a bill wasn't paid, Bronson filed the typical provider suit that we all know and love, seeking reimbursement for medical bills arising out of some treatment. USAA moved for summary disposition, arguing that the assignment was void as a matter of law because it was signed before the patient actually received treatment. Like I said earlier, as a part of their standard operating intake procedure, Bronson would have their patients sign this assignment of rights. Bronson did not agree, obviously, with USAA's position and argued that the assignment was executed contemporaneously with the patient's treatment and therefore did not violate MCL 500-3143. Bronson also argued that the PIP benefit was only payable when the loss accrues and that an expense was incurred by the patient when they signed the contract for products and services. The district court denied USAA's motion, and the respective circuit court denied its application for leave to appeal. USAA then moved for leave to appeal in the Michigan Court of Appeals, and that appeal was granted. The Court of Appeals highlighted MCL 500-3143, which provides that an agreement for an assignment of a right to benefits payable in the future is void. The court then delineated the confines of MCL 500-3143 and went into what exactly constitutes a future assignment. The court indicated that MCL 500-3143 requires a focus on a point in time at which benefits would be payable in comparison to the point in time at which the assignment was executed, precluding an assignment for benefits payable in the future, and the statute does not place any temporal restrictions on defining future. For example, benefits first payable 5 days or 5 minutes in the future, 5 days or 5 minutes after an assignment has been executed, cannot be assigned under MCL 500-3143. At the exact moment here that the patient signed the assignment, he had no right to any benefits because the benefits were not payable unless and until minimally the treatment was received or services were performed. Any conclusion to the contrary does not support the statute MCL 500-3143. The court indicated that a no-fault insurer cannot be obligated to pay benefits until after the medical services are actually provided. Moreover, a healthcare provider would not be entitled to payment without having yet treated the patient. Here, in no form or fashion did the patient assign a right to past or presently due benefits. Absent the performance of services, there is no financial liability, regardless of whether the patient may have signed an agreement to pay. For example, had the patient chosen to walk out of the emergency department without receiving any treatment after executing the assignment, Bronson, the plaintiff here, would have no basis to demand payment from the patient and certainly not from USAA, even if the assignment identified the specific medical services that were planned. Ultimately, the court held that an assignment executed by a patient upon presenting for medical treatment was valid, but prior to any such treatment actually being rendered, constituted a future assignment within the meaning of the statute. This case simply provides future or additional support for our motions that defendants typically have to file when we see these future assignments, a lot of times in toxicology cases or cases where urine samples have been collected. We see this issue a lot. So this just further delves into that and provides additional support. And lastly, the case of L. Ashkar v. Centennial Insurance Company. This accident arose out of the same accident as the famous case of Bazzi v. Centennial Insurance Company, both of which were defended by my office, specifically our senior partner, Mark Masters, who of course did an amazing job in defense of these cases. As you most likely know, Bazzi confirmed that in no-fault cases, the innocent third-party rule has been abrogated and insurers may rescind automobile policies based upon fraud in the application for insurance, even when the innocent third party seeks statutory PIP benefits. Bazzi further noted that rescission is an equitable remedy and not an absolute right. Before the claim of an innocent third party can dismiss, there must be a balancing of the equities. Here, plaintiff L. Ashkar suffered injuries as a passenger in a 2012 motor vehicle accident in Dearborn. A white Honda, driven by L. Ashkar's friend, Ali Bazzi, traveled over 100 miles per hour on westbound Ford Road and collided with a black Dodge pickup that had lawfully completed a turn onto the roadway. Both of the passengers were ejected from the Honda and suffered injuries and sought PIP benefits from Centennial, the insurer of the Honda. The vehicle Ali was driving was owned by his mother, Hala Bazzi, and insured under a commercial automobile policy, obviously issued by Centennial. Both passengers sought PIP benefits under that policy. Centennial then went on to argue that the policy was fraudulently procured by Bazi's mother, Hala Bazi, in order to obtain lower premiums because of Ali's involvement in a prior accident. Centennial argued that the vehicle was actually leased to Hala Bazi and or her sister for personal family use and not for commercial use, and that the corporate named insured under Centennial policy was a shell company. Centennial also argued that Hala failed to disclose that Ali would be a regular driver of the vehicle, and then went on to file a declaratory judgment against Hala and her sister, which resulted in a judgment for rescission of the policy. Bazi went all the way to the Supreme Court, and the Supreme Court clarified how rescission applies to innocent third parties. The trial court did consider Ali's claim on remand, but found that the equities favored Centennial. This ended Bazi's suit, Ali Bazi's suit, and the trial court then turned to El Ashkar's action, which had been filed shortly after Ali Bazi's action and had been stayed throughout the Bazi appeal. Although Ali could not make a claim under the policy, the trial court found that El Ashkar could under Bazi's equitable balancing test. Although the Bazi opinion did not specifically detail how to balance the equities, subsequent case law went on to determine 5 factors that should be considered. Here the factors are whether the insurer could have uncovered the subject matter of the fraud before the third party was injured, whether the relationship between the fraudulent insured and the innocent third party suggests that the third party had knowledge of the fraud, whether the innocent third party's conduct played a role in the injury-causing event, whether the third party has an alternate avenue for recovery, if the insurance policy was indeed rescinded, and lastly, whether the policy enforcement only relieves the insured of what would otherwise be the insured's personal liability to the innocent third party. So here the court balanced these 5 factors. With regard to the first factor, the court said that neither weighs for or against rescission because although Centennial could have done more to discover the fraud before the accident, the perpetrators of the fraud may have concealed their fraud from the insured. The second factor was found to cut against rescission because, unlike Ali, El Ashkar had no relationship with Hala, Ali Bazi's mother, or the corporate insured, and he had no knowledge of the fraud. The third factor was also found to cut rescission because, unlike Ali Bazi, El Ashkar rode as a passenger in the Honda and lacked control of the ensuing events, i.e. the crash that caused the injuries. With regard to the fourth factor, Ali Ashkar lacked any other insurance policy which he could claim benefits from. Again, obviously this weighed against Centennial, and the panel therefore rejected Centennial's argument that rescission was equitable because El Ashkar could obtain coverage from the MAIPF or the Michigan Automobile Insurance Placement Facility. The panel found that because benefits were only payable from the MAIPF after rescission had been deemed proper, because the MAIPF is an insurer of last resort, the availability of coverage through the MAIPF should not be considered as a part of the balancing test. The panel found that the fifth factor also weighed against rescission because enforcement of the policy would not transfer Ali's tort liability to El Ashkar from the insured. Finally, the panel went on to reject the defendant Centennial's argument that once a policy has been rescinded, as was the case here, only 2 considerations are relevant: whether fraud or misrepresentation existed at the inception of the insurance contract that was material to Centennial's decision to issue the policy, and 2, whether the facts establish that the insurer failed to rescind and or continue to collect premiums after it had actual knowledge of the true events. The panel found that this could not be reconciled with the Supreme Court's holding in Bazi. The trial court's holding that Centennial was responsible for El Ashkar's PIP claim was therefore affirmed. I think this case is further evidence that the balancing of the equities is so very important, and that the case of Bazi v. Centennial has changed the way these cases are litigated. The balancing is so sensitive, and it could go either way depending on the factors and how each passenger in the car can have an entirely different outcome depending on the balancing. All right, moving on to the second part of my PIP Monthly, trending topics in PIP litigation. As you all know, on May 24th, 2019, the Michigan legislature passes a sweeping auto insurance reform bill that went into effect June 11, 2019. Of note, some provisions did go into effect at later dates. The legislature highlighted that the no-fault reform was necessary to combat fraud, provide options for coverage for Michigan residents, and reduce the highest insurance rates in the country. We have done several My PIP Monthlies and webinars on no-fault reform, but today I wanted to specifically highlight no-fault reform and the one-year back rule. Prior to the implementation of no-fault reform in June of 2019, MCL 53145 read in pertinent part, an action for recovery of personal protection benefits payable under this chapter for accidental bodily injury may not be commenced later than 1 year after the date of the accident causing the injury, unless written notice of the injury has been provided to the insurer within 1 year of the accident, or unless the insurer has made a payment for personal protection benefits for the injury. If the notice has been given or payment has been made, the action may be commenced at any time within 1 year after the most recent allowable expense, work loss, or survivor's loss benefit has been incurred. However, the claimant may not recover benefits for any portion of the loss incurred more than 1 year before the date on which the action was commenced. For example, if an accident occurred on May 1st, 2018, and the plaintiff does not file suit until May 2nd, 2020, all benefits before May 1st, 2019 will be barred. This was a well-settled rule that was interpreted by the Supreme Court in various cases, one of which is the Devilers v. Auto Club Insurance Association case that went on to discuss that there are 2 limitations on the time for commencing an action and 1 limitation on the period for which benefits may be recovered. 1, an action for PIP benefits must be commenced no later than 1 year after the date of the accident, unless the insured gives written notice of the injury or the insured previously paid PIP benefits. 2, if notice has been given or payment has been made, the action may be commenced at any time within 1 year after the most recent loss was incurred, and recovery is limited to losses incurred during 1 year preceding the commencement of the action. We've also seen cases where an accident occurs on one date and then the insurer has no knowledge of the accident, no knowledge that the plaintiff or claimant was seeking treatment, and then 2 years after the accident, all of a sudden someone calls into the insurance company and attempts to make a claim. Obviously, situations such as that are extremely prejudicial and unfair to the insurance company because people could just call or, create accidents or make claims for accidents that occurred 5-6 years ago, and the insurer would have no way to prepare for the same. Also, it's important for the insurer to be able to defend, analyze, and do discovery regarding these claims or these accidents. And by that, I mean, for example, send the plaintiff or claimant to medical examinations or review the claimant's pre-existing medical records. Situations like that are very time sensitive. Like I said previously, various panels of the Supreme Court have consistently ruled and reaffirmed its interpretation of the 1 year back rule. In the case of Aldrich v. Auto Owners Insurance Company, Allstate v. Frankenmuth Insurance Company, and English v. Home Insurance Company. All 3 of these cases are seminal, important cases, but they all essentially say the same thing. However, MCL 53145 was recently amended on June 11, 2019 to include the following. 1. An action for recovery of personal protection benefits payable under this chapter for an accidental bodily injury may not be commenced later than 1 year after the date of the accident that caused the injury unless written notice was provided in subsection 4 and has been given to the insurer within 1 year after the accident, or the insurer has made a payment for PIP benefits for the injury. That's the same. 2. Subject to subsection 3, if notice has been given or a payment has been made, the action may be commenced at any time within 1 year after the most recent allowable expense, work loss, or survivor's loss has been incurred. However, the claimant may not recover benefits for any portion of the loss incurred more than 1 year before the date the action was commenced. That's the same as well. A period of limitations applicable under subsection 2 to the commencement of the action and the recovery of benefits is told from the date of the specific harm for payment of the benefits until the date the insurer formally denies the claim. This subsection does not apply if the person claiming the benefits fails to pursue the claim within reasonable diligence. So that's the difference here. The insurer needs to formally deny the claim in most situations, but this does not apply for situations, as I said earlier, should not apply, where the plaintiff or claimant gets into an accident and just simply does not notify the insurer. The insurer one day gets called 2 years after an accident providing notice. I'm not sure it would be fact specific to determine what reasonable diligence is, but I think it would be safe to say that reasonable diligence is not 2 years. But again, we would have to delve into specific facts of a case. Again, pursuant to no fault reform, the 1 year back rule is told from the date of a specific claim for payment of the benefits until the date the insurer formally denies the claim. Again, like I said, the term reasonable diligence will have to be fact specific, and you can expect to see a lot of litigation with respect to that term. But what's most important here that I wanted to highlight today is that difference in the no fault reform, that an insurer should formally deny a claim if possible. That's all we have for today. Thank you for attending my PIP Monthly. Please feel free to contact us with any questions, comments, or concerns you may have. My name is Amber Rouse Holloway, and I am a partner here at Secrets Wardo at our Troy location. Thank you.